Often these judges are relying on statutes and precedents that were written 100 years ago or more by people who couldn't even conceive of the technology that we had today. And I'm sure when they wrote the Bill of Rights in 1791, they couldn't have fathomed a computer, much less an AI system. So how do we reconcile the words that are written down centuries ago and the spirit of those words, and even trying to interpret the spirit of those words as we're talking about brand new, conceptions
Yeah.
to reckon with today?
I think in every case involving complex technology, we're trying through amicus briefs or directly in the main party's briefs, if we're directly representing a litigant, to offer the kind of very basic explanation of how the tech works. Because you can't launch into a First Amendment defense if the judge doesn't understand the underlying technology. It's so dependent on the facts.
The other thing that goes on is that these parties, especially companies, are extremely strategic in how they think about the litigation they're going to bring. So, more than a decade ago, when Google started litigating this question of whether their algorithms were protected by the First Amendment, and they leveraged actually cases that, we used to celebrate. I was on the board of EFF, and EFF was strongly behind the idea that encryption should be constitutionally protected, because encryption is code and code is speech. And in that context, people celebrated that protection against the government's overreach of encryption technologies. Google built on that to begin to establish a First Amendment barrier around the idea of regulating what looks like the regulation of algorithms on the same basis. And that's what grew into the reality that we have right now, where they take it for granted that they're just going to be applying either intermediate or strict scrutiny in the context of this kind of regulation. And that's where I think that the judges need to just pause for a second and realize that even if it made sense in the context of regulation of encryption back in the day, we need to be rethinking its application. The reason this is so catastrophic is not really where we are just now, although character AI is catastrophic for the particular people who've been harmed. But the real reason this is catastrophic is if we imagine where we're going to be in 5 years.
Mm-hmm.
Because if we're in 5 years, the world, that seems obvious we're going to be living within, when these AIs are among us all the time, doing everything with us. I mean, you and Aza did this wonderful talk where you talked about 2024 being the last human election. I mean, when you talk about how it's going to play in elections, how it's going to play in the market, how it's going to play everywhere. If you say that you can't regulate any of this stuff, we're toast. We're just toast, right? And so if that can't be, then let's read back and figure out what should we be saying now to make it clear that's not what the First Amendment has to read. The First Amendment doctrine that gets applied in these cases has nothing to do with the words of the First Amendment. The First Amendment doctrine that talks about content-based, content-neutral, strict scrutiny, intermediate scrutiny, none of those words are in the First Amendment. This is a doctrine that was crafted in the 1960s and 1970s that became the doctrine that we call the First Amendment. I'm actually litigating a case trying to get the court to right now apply the original meaning of the First Amendment to campaign finance regulations, because anybody would know who knows the history that the First Amendment, as originally understood, as originally meant, would have had nothing to do with the regulation of campaign finance the way it's being regulated right now. Indeed, Josh Hawley, no liberal, introduced a bill to overturn Citizens United. And when he did so, he said, every good originalist knows that the original meaning of the First Amendment would never have limited Congress's ability to control how corporations spend money. So the First Amendment, as originally understood, would have a radically different scope than the First Amendment as it is now interpreted. And so that's not to say we should give up the idea of free speech. I have lots of principles that I think we all should agree on. So you shouldn't have a law that says Republicans can't speak, but Democrats can, or Republican bots are allowed and Democratic bots aren't. I mean, that's fine. But the doctrine we've evolved is not a doctrine that has anything to do with what we, the people, ever affirmed in a supermajority way.
I agree with that. I think that the words that we're kind of contending with are really more recent creations of courts. I mean, both statutorily, often one of the defenses that we're having to battle in court is Section 230 of the Communications Decency Act. That's from the late 90s. I mean, that's also from a much earlier stage of the internet, and the technology has evolved so much, and yet we're still stuck there. And similarly with the First Amendment, I mean, as Larry has said, we're dealing with a doctrine that's 50 years old, and the paradigmatic notions of that First Amendment and how it came to be through evolution was very different from what we see today in terms of how it's been weaponized very conveniently and persuasively by the tech industry.